Good evening, everyone. I'm Billy. I'm an alcoholic. Everyone can hear me. Awesome. So, anyone last week? I know I got some messages. We put off a week, but if there's anyone still out there who's struggling with power or whatever, I know there's very few left, but I still know there's some in Tennessee who don't have power. Um, but I have actually made a poor choice of houses tonight because I'm in the Great North where it is freezing. So, if any of the rest of you are there, but um, tonight we are going to tackle the hard, complex subject of the AAWS bylaws, um, which we put off a while ago. I do want to say, I do want to put out there only because, in honor and respect, that today the board met um, and had their official board meeting after being there all weekend with the delegate chairs. And while we don't know the outcome of any of that, what we do know is they know what's going on the final conference agenda. And that for the next couple of weeks, staff will be working really hard, putting together the final background for anything that's on the final conference agenda. And somewhere in the next 2 weeks, probably between the 14th and the 18th, we will start to see background start to come out. So before we get going with this, I just want to ask anyone who is here right now, if you have a question about the conference process and the final agenda and the background, and I want to make clear, not a question about anything that could be on there. That's not our business, definitely not my business, or an opinion about something that would be on there. That's for you to take to your district or your area and sort out with your delegate. But if you have a question about the conference process, I would accept a question or two or three right now, if anyone has it, before we go into the bylaws, Appendix P of Alcoholics Anonymous World Services, Inc. Okay, I don't see any questions. I'll give it another couple of seconds. Okay, so that is over. That means all of you know everything you need to know, and I hope you are helping other people who are not as lucky as all of you, who are very confused by this whole process. Um, just imagine if you were a new GSR who started like 30 days ago, 31 days ago, and the conference agenda and background is going to come out 6 weeks into being a new GSR who's never been to an assembly, maybe was not an alternate GSR. So please do your part. We have a lot of people out there who we don't need them leaving service because they feel like they're drowning. That is for sure. So, Appendix P, which is on page 143 of the current service manual that I have, are the bylaws of Alcoholics Anonymous World Services, Inc., which is one of our three corporations, one of our two service corporations, and a fully independent legal company, as we are going to see as we go through this, through their bylaws. Now, a long time ago, the General Service Board itself, that company, that corporation, used to own AA World Services and the AA Grapevine. But today they are independent companies, and what makes them part of the overall is that their members, with a capital M, are the trustees of the General Service Board. So they are the quote unquote shareholders, for lack of a better word. Under the not-for-profit law in New York, those members act as owners. So what does it say? Article 1. A business office of this corporation shall be located in such a place within the city of New York as may be fixed by the board of directors. The corporation may establish and maintain offices in any of the states of the United States, possessions, cities or towns therein, and in such places as may from time to time be appointed by the board of directors. So what's an interesting thing there? Probably not a lot. However, if you're from Canada, there's a lot there. It's the General Service Conference structure of the United States and Canada. And yet we just read something which clearly prohibits the office could be anywhere except for outside the United States. So there are some cross-territorial issues that we have to deal with that are not always fair, you know? It bothers me greatly that Canadians do not have an equal chance to work at our General Service Office that United States citizens do. And it's just because we are the same structure where the structure of both countries. But it's very difficult for a Canadian to work at the U.S. General Service Office because of the employment laws that are out there and the laws around getting a work visa to work in this country. So Section 2 says the seal, the corporate seal, shall be circular in form and shall inscribe the name of the corporation, the year of its organization, and the words corporate seal. For those of you that, might not know this, there might be a few people here, I'm sure, who do, but there actually is a corporate seal. If any of you ever knew a notary, most notaries use the quick rubber stamp, but notaries also get a seal if they want to look really official. Each corporation has a seal. Article 2, members and meetings of members. So this is where it could be very confusing because one might think, members of what? Members of the board of directors, like the board members of AAWS? It's not what it's referring to. It's referring to the trustees in their capacity as a member of the corporation, AA World Services. So it says, Section 1, membership. The membership of the corporation shall consist of the trustees of the General Service Board of Alcoholics Anonymous, Inc., parentheses, the General Service Board. No one shall be elected to membership in the corporation, nor shall person continue as a member of the corporation unless said person shall contemporaneously serve as a trustee of the General Service Board. So that when you become a trustee, you become a member of 3 corporations: the General Service Board, Inc., AA World Services, Inc., and the Grapevine, Inc. So I've had so many calls and emails over the years when people think member means a member of the AAWS board, but that's director. This is member. And we're talking about members and the meetings of the members. So who are the members? The trustees. Rights of the members. The right of a member to vote and all of the members' right, title, and interest in or to the corporation or its property shall cease upon termination of membership. So when I stop being a trustee, I stop being a member of AA World Services. Annual meeting, Section 3. Now, I'm sure there are people here who have listened to me say before, there is only one place usually you can find all of this legal versus spiritual kind of gobbledygook in writing, and that is the meetings that take place after the General Service Conference that afternoon, when this annual meeting, that's where it takes place. It's the only time you'll see minutes for the members of AA World Services. unless there's a special meeting called during the year, which there usually never is. But here's what it says. The annual meeting of the members of the corporation shall be in the state of New York on the day immediately following the scheduled close of the General Service Conference. So when they say following the close, because remember, the General Service Conference technically ends on Friday night. So Saturday in the morning, there's a kind of, they call it brunch, but it's at 9 o'clock, which means breakfast, I think, for the rest of us. Brunch is like 11 o'clock or later, I think, to most people. But there is a rotation brunch where trustees give their rotation talks. And then after that are the board meetings. This is what they're talking about. On the day immediately following the scheduled close of the General Service Conference, as required by the Not-for-Profit Corporation Law of the State of New York, NPCL for short, the Board of Directors shall present to members at the annual meeting an annual report for the most recent ended fiscal year of the corporation. The report shall be certified by the corporation's independent public accountants or otherwise verified as provided in Section 519 of the Not-for-Profit Law, and shall contain at a minimum all information required to be included therein by the N Non-for-Profit Law 5, Section 519. So the meeting of the General Service Board kind of ends. It comes to like, they kind of go to pause and they open up a meeting of the membership of AA World Services. That's how that technically looks that afternoon. And then when they say the directors, when they say right here, the board of directors shall present to the members. So the AAWS board, through their chair, presents to the trustees their report. That's what it's saying. That's what happens right there. Section 4, notice of annual meeting. Written notice of the date, hour, and place of the annual meeting shall be given either personally by first-class mail with postage thereby prepaid, by electronic mail, not less than 10 nor more than 50 days before the meeting, to each person who appears upon the books of the corporation as a member. And if mailed, and such notice shall be directed to the member at the member's address as it appears in the books of the corporation, unless such member shall have filed with the secretary of the corporation a written request that notices intended for the members shall be mailed to the addressee designated in such request. That's a lot of complicated talk. But what it means, again, talking about members, is the trustees. Those are the members of AAWS. That's who has to be advised of the meeting. And one of the things that gets forgotten, and there may be somebody here who's been down a similar rabbit hole, perhaps, our guidelines and most of our processes and procedures in AA, you could say, are spiritual documents. But bylaws are legal documents. And where does every AA service entity get in trouble? And, you know, I know a lot of people complain about what goes on at GSO, but I'll tell you one thing that GSO does a hell of a job of, and that is keeping the legal and the spiritual both very kept track of. Do you know how many areas that are incorporated or intergroups that are incorporated fall into trouble because they forget to have their annual meeting, because they don't have minutes of their annual meeting, because they think that they forget about the legal requirements to be a not-for-profit corporation. And it happens all the time. Sometimes I know this story many times where someone who is elected to a position, like they became a chair or a treasurer of an intergroup or an area or something, and just for the fun of it, went on their Secretary of State website, on their state website and found out that their corporation was no longer in, like it fell out of compliance. There's so many of those AA stories. And, I just want to stress, like, if you are part of an AA service entity that has become a corporation, a non-for-profit corporation, please make sure that you are keeping up with the legal requirements that you have. Um, Section 5 is notice of special meetings and what has to happen if there's a special meeting. Um, I want to talk, though, about the annual meeting, just because it's a place where the spiritual and legal meet. So, a quick review. Who's on the AAWS board? The general manager, the staff coordinator, 3 non-trustee directors. Okay, now we're up to 5. And the other 4 are trustees, usually 2 general service and 2 regional. So at that meeting, what happens is the conference has already decided spiritually who will be on the board. We call it the slate. And the conference committee on trustees, by the time Saturday happens, we'll just back up like 2 days. It's Thursday at the conference or Wednesday, and the conference committee on trustees has presented its report to the conference. And in that report are some recommendations about who should be on what slate. One of those is the slate of the AA World Services Board. So the conference, by a 2/3 vote, is spiritually telling the trustees, this is who is going to be on the AAWS board. And then at the meeting on Saturday afternoon, the trustees have to legally vote because the vote at the conference has no legal implications. It has spiritual implications that if the conference tells the trustees what to do by 2/3 or more, it's an advisory action. The trustees have to follow that. So what the trustees are doing on Saturday is legally putting into place the directors that have already been put on the AAWS board by the conference. But since the conference is not a legal entity, only the members of AAWS can do that. The trustees acting in their capacity as members. That is so complicated. Somebody asked a question, do the trustees not also serve as the board of directors of the GSB? If so, does that make them the members? So when we went through the General Service Board bylaws, yes, if you are a trustee, you are a member of the General Service Board of AA Incorporated, and you are also a director. We don't throw around the director term spiritually when it comes to the General Service Board of the trustees, but legally, each trustee is a member of the board of directors of the General Service Board. Another question came in. Is it mandatory to have special meeting presenting agenda items to the home group once we get the agenda? Oh, here's a conference question. Okay. This is one of those places where your group gets to embrace tradition 4. And you get to have a lot of autonomy around how you go through agenda items for the conference. Now, we have AA groups that go through none, 0. And we probably have a couple AA groups that go through every one of them, believe it or not. But the rest of us fall somewhere in the middle. So asking me if you should have a special business meeting, I don't know. I would talk to people in your area how they handle it. We don't know how many items are going to be on the final agenda, but there's a good chance it's going to be 70 or 80 or more. Even if it's 60, it's a big number. My suggestion, and this is not anybody can do what they want, is to go through the agenda with someone who's very familiar with it and find out what on a group level do you think is going to find they're going to be interested in? Because while this might not be wildly popular to say, there's a lot of items on the General Service Conference final agenda that the GSR should have a lot of right of decision to deal with. You can't expect your average group member to have as much information as you do. But there will be items on that agenda that your group is going to dig into. The fifth edition of the Big Book. We have no idea what's going to happen until a week or two from now. But there is a very good possibility that the conference, the trustees literature committee, forwarded a draft to this year's conference. I do not know if that happened, but I know it was possible. If that happened, only the members of the conference literature committee get to see that draft before the conference, which means that there's going to be some kind of reading room established at the conference, like there was for the plain language Big Book, and time set aside for delegates not on the literature committee to read the stories that have been added and obviously then see the stories that have been taken out. Even though your delegate, if not on the literature committee, doesn't get to see it, your group might have lots of questions about that process. And that would be a good thing to go over with your delegate. How is that process going to work? What's it going to look like? When my group says, hey, how does this get approved and no one gets to see it? Rather than have bad information like that get out, find out what the process is from your delegate for the fifth edition. There's probably going to be some other items on that agenda that alcoholics like to talk about, you know? So I can't tell you if you should have a special business meeting. I can tell you that you should talk to people in your area, in your district, and see how they do it. And you should know your group's temperature better than anyone else. Do you extend the business meeting for like a half hour? Or do you have a special one or two business meetings? But that is definitely not for me to decide. Who keeps up on these legal compliance matters for AAWS? Do we have a hired counsel? Is it something that the GM does as a job description or some other arrangement? It's a great question. So there are a bunch of outside counsel that work for the three corporations, but one of them serves as kind of like our outside general counsel. That lawyer is very familiar with all the not-for-profit laws in the state of New York. In fact, the one we use used to work for the Attorney General's office in the state of New York in the Division of Charities. So yes, we have a lawyer that keeps track of it. And then the assistant secretary and secretary of each corporation that are the assistant secretary is a staff member. The secretary is a one of the trustees or one of the AAWS members. That is also in their job responsibility that they're always looking at these dates and stuff. And the general manager is obviously serves as the president of the AAWS Corporation. But yes, it's a lot of work. And maybe that's why it falls through the cracks on a lot of intergroups and areas. They just don't give it the time that it deserves. But I'm the first one to always tell people, if you're going to become a not-for-profit corporation, make sure you know the kind of work that's involved with it. in your state, um, everybody thinks, I think the urban myth in AA is you write a letter to the IRS, you get them all your information, and you get the letter in the mail that you received your 501(c)(3) designation. And I think one of the problems is that people confuse tax with compliance, governance as a corporation. Is that the IRS just declares you a not-for-profit from a tax point of view. But inside your state or territory, you have to register with the Attorney General's office, usually in the Division of Charities and Nonprofits. And they have a lot of compliance rules that are annual, not just getting your 501(c)(3) status and running along. It's usually in those state required governance matters that we fall short or stop doing. And then I see this. It's funny because I can see at least two people. One's a lawyer, one's not, but the one who's not is very familiar with nonprofits. Sometimes people will say, oh, we had an annual meeting. It was our January assembly. Nope. You have to have a separate set of minutes for the legal meeting that is properly labeled as the annual meeting of the corporation. The state does not want to see minutes that say the January AA quarterly assembly. That doesn't mean anything to them. They need to see the meeting of the minutes of the annual meeting that shows the members who were present and the business that you have to statutorily do, like get a report of the corporation from the directors, select an auditor. Your state, I'm not going to go through them because your state has different rules, but it's always these state rules that we always seem to fail in compliance with. So all I can do is suggest that your eyes be wide open. But I'll also give you a little bit of warning. If you are the person who discovers you're out of compliance or sees that you're basically about to go out of compliance, when you bring that up, you will not be a popular person. And just letting everyone here know that. But thank you for your service if you do it, because there have been AA service entities that have had horrific consequences. Losing your not-for-profit registration in that state is not a good thing. Not finding out how sales tax is handled in your state is a very dangerous thing. I don't even like to talk about it when I'm on a multi-state platform like this, but I can just give you an example. By raise of your hand, virtual or regular, who here knows that if you're a nonprofit corporation, you can get a certificate that you can show when you go to the store and not pay tax? Who knows that? Okay, I'm looking around. Oh, a lot of you. Okay. So let's start there. That's a very good place to start. That's a very valid thing to do. You're a not-for-profit corporation. You're going to make some purchases. You go to the local supermarket. You say, I'm tax exempt. They say, do you have a copy of your certificate? You say, I do. They make a copy of it or whatever, or they put one on file. That's the way it's supposed to go. Okay. Now, in some states in the United States, if you're a nonprofit, you don't have to charge sales tax when people buy books from you or other items. But in some states, you have to collect their certificate because you're not charging them sales tax. Now, we all know how many AA groups have certificates like that. Basically none. A lot closer to none than 100% because they're not-for-profit corporations. Now, in some states, we're very lucky. If you're selling literature for your organization, they give you an exemption. You don't have to collect sales tax. In other states, nonprofits don't have to collect sales tax at all. However, you see that I'm being very careful by saying some, because it's not all. We have one in a group in the United States that a couple of years ago had to pay back $27,000 in sales tax because in the state they're in, individuals don't get away with not paying sales tax, even if they're buying it from a nonprofit. And that in a group did not ask for certificates or charge sales tax to individuals or AA groups. And they got audited. And, we know in AA, $27,000 is a lot of money all at one time. And there's other things that can happen. You could lose your nonprofit certain AA entities go above the threshold of having to file tax information every year. I'm not going to give tax advice here, but you should be talking to an accountant and know the dollar number of when you have to file tax paperwork and when you don't. But I'm going to tell you right now, if you're above that threshold and you don't for a couple of years, you're going to lose your 501c3 status. That is what the IRS is going to do. And the last thing I want to say about this, I almost feel like there should be a separate school or book in AA about this. There is a trade-off for being a non-for-profit corporation. When the government tells you you don't have to pay taxes, they expect you to act better than a for-profit corporation. It doesn't come for free. There are certain regulatory requirements that you have to live up to. And I would tell you that AA World Services, AA Grapevine, and the General Service Board do an awesome job at this. I'm just going into detail about the other because I know the kind of people that are here tonight, or the kind of people that will listen to this recording, are the kind of people that get involved on committees and intergroups and areas and districts. And this stuff, there's no book about it anywhere. There's not even a section of the service manual called Staying in Compliance with Your State and Federal Guidelines. There's nothing out there. And it's almost, I don't want to say criminal, but the ease that you can become a non-for-profit or not-for-profit corporation is so simple. It kind of makes people think I must not have to do anything to keep this. Like it was so simple to get, but it's one of those things that it's harder to keep than to get, in my experience. So I just don't want to be in a soapbox about this, but when you've been through the pain of going through one of these non-for-profits that gets in a little jam, you really start to say we could do a better job. Article 5 is about special meetings for election of directors, and it says, if for a period of 1 month after the date fixed by under the bylaws, the annual meeting of members, if no date has been so fixed for a period of 13 months after the last annual meeting, there's a failure. So it's talking about, it says there is a failure to elect a sufficient number of directors to conduct the business of the corporation. The board shall call a special meeting for the election of directors. What these bylaws are doing is trying to predict every possible scenario, which most lawyers will tell you is impossible. Just when you think that you have documented in your bylaws every possible thing that could have happened, the one you didn't think of happens. So, you know, I want to go to section 6, place of meetings. It says the board of directors may, in its sole discretion, determine the meetings of members be held partially or solely by means of electronic communication. The electronic service center or platform by which the meeting is held shall be the place of the meeting for purposes of this article. If a meeting is held, so what it is doing, it was updating us that we can have not only a board meeting, but a meeting of the members by electronic means. Section 7, notice of special meetings of the members. Written notice of the special meeting stating the date, hour, place, and purpose of the meeting thereof shall be given personally by first-class mail. Postage thereon prepaid by fax or electronic mail to each member, not less than 10 days nor more than 50 before such meeting, and if mailed, such notice, blah, 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 blah. The only time I've ever seen this used is when someone is being removed. It happens very rarely. That's when you need a special meeting, that you need the board legally back in place. Or if a trustee, because remember, so it gets complicated again. Let's say someone who is serving as a trustee, but also on the AAWS or AA Grapevine board, passes away or gets sick. That's happened many times. So another trustee needs to serve usually on that corporate board until we elect the new trustee during the next time. So that trustee has to be elected to that corporate board, even though the general service board will say, oh, we're going to pick Tom or Susan or Debbie to fill in. They don't have the legal authority to do that as the general service board. They have to have a special meeting of the members of the AA World Services Board. So sometimes special meetings happen for that purpose. Quorum, Section 8. Members entitled to cast a majority of the total number of votes entitled to be cast therein shall constitute a quorum at a meeting of members. In the absence of a quorum, or when a quorum is present, a meeting may be adjourned from time to time by vote of a majority of the members present in person without notice other than by announcement at the meeting. So again, I don't want to bore you to death, but we have had to make so many rules. And mind you, even when we get to Section 10, and Section 9 is waiver of notices, and Section 10 is about the order of business. It tells you at meetings of members of the corporation, the order of business, except when otherwise determined by a vote of 2/3 of the members present in person, shall be. This is what your annual meeting needs to look like. This is it right there. But we're not even at the board of directors yet. We've only been talking about the members. Isn't that incredible? Article 3, Directors, Section 1 is when we start to talk about the board of directors of AA World Services. Article 1, Article 2. Article 1 has 2 sections. Article 3, Section 1, all the way to Section 10 is just about the members, just about the trustees in their capacity as basically the owners of AA World Services, Inc. That's how complicated this can get. And I'm not saying you all need to be an expert on it, but I am telling you this. If you're on your local intergroup board, or if your area has incorporated, somewhere buried in some box with coffee stains on it, because it was probably made before there was anything digital, these bylaws are sitting somewhere. And they've never been updated. They probably, and I'll throw out a helpful hint, and If you are on in a group or area, let's just say one of those offices, if you're on the intergroup steering committee, if you're on areas kind of usually have people who like serve in the legal capacity for their corporation. This is going to sound very elementary, but when I've asked around the country, very few people do it. When you have a new round or term of office, everybody should get a copy of the legal bylaws. It should be something that's part of the transition when you elect the new panel or you elect new intergroup offices at, at intergroup or a new steering committee. Whoever is considered to be one of those legal directors, they should get a copy of your bylaws. And I'm not talking about your guidelines for your area. I'm talking about the legal bylaws that are in place for that corporation. Any questions about any of that? Or anybody, this is such an important topic because of the problems that come up, especially in local AA. Is there anyone on here who has anything they want to share of any in 2 or 3 minutes? Have you been part of any AA entity that's had to deal with an issue like this? I would love to hear it. No brave volunteers, but that's okay. I would ask this, is there anyone currently here who is either an officer in your general service area or on an intergroup board who knows that you also serve in a legal capacity for the nonprofit corporation? Does anyone here know that they definitely have that status in life? If you would raise a virtual hand, I would at least know. I have one, two. I have at least two. Okay. Of those two people, I would be curious when you came into office, were you given a copy of your corporate bylaws? If you would just send me a message, I would love to know. Somebody just told me they're standing for steering committee and this is helpful to know. Oh, people are going to love this answer. Someone just said no, they were not given a copy of the bylaws when they came into office, but they found them in a box. It's like they predicted what I said. That is hilarious. Um, Anybody else want to care to share if you were given a copy of your bylaws, your corporate bylaws? Okay, you can take your hands down. So it's just so common, this problem. Um, it really is really common. So let's move on to um, let's see. There's a question here. Who ultimately holds fiduciary duty if you get a bill like that in a group for 27K in the area the group doesn't have it? Hmm. Well, let's talk about that. The corporation owes the money, but we're talking about corporations that get their money from groups and literature sales. It becomes a very complicated matter because a lot of AA entities don't have $27,000 sitting around. Sometimes they have to set up payment programs with their state tax office to pay, some every month to pay it back. Some don't have the money to pay right away. The one thing I can tell you is If something like that happens, disclose it to the groups quickly. Don't hide it. Don't try to fix it by yourself. You know, the good news, if you're the current officer that found it, is it's probably not your mistake. It probably was made years before you. You don't have to name the people who made the mistake, but you do have to let the groups you report to know what's really going on. So if we go to Article 3, directors, let's see. Oh, this is a great comment, and I'm going to not give any legal advice because I'm not a lawyer, but I'm going to tell you, as someone who's consults for a lot of nonprofits, this happens all the time. They just wrote to me, when my area was sued last rotation, the other offices did not know they were personally liable. So you, AA sometimes acts like we're above the law. Sometimes acts like all of these things don't apply to us. And we talk about insurance, and none of us are. That's the one thing I can say I have a professional license in, but very few of us are experts in insurance. And you have to understand that, like, when you go on a board of directors, you could be held responsible. There's something the corporation could have did wrong, but then there's also something the directors could have done wrong. And depending on the state, there are places where the directors of a corporation can be personally held liable if they operate in a way that's not consistent. Sometimes you'll hear a term called piercing the corporate veil. And what does that mean? Well, you have a corporation to protect yourself so that individuals are not legally responsible for what a corporation does. But you don't get the protection of a corporation for free. The courts expect you to act in a reasonable way, like not having insurance. You know, like I said, I'm not a lawyer and I don't practice law, but I consult for a lot of nonprofits. And I can tell you that in many states, one of the ways to pierce a corporate veil is to show that a corporation is undercapitalized and underinsured. In other words, the corporation intentionally was not paying for the proper amount of insurance it should carry. And as a result of intentionally not doing that, the directors of that corporation could be personally liable. It's just beyond my comprehension, because I'm just going to tell you, nobody talks about these things until something really bad happens. Up until then, the common thing you're going to hear from a lot of experienced, trusted servants is that you don't trust God. What, you don't trust God, Billy? You don't trust God. God's taking care of AA. God has this handled. Actually, God wants us to take care of it. That's part of why God got us sober. Whether you believe in God or not, it doesn't matter. We're not absolved from certain responsibilities. And, I just want to point out, and I'm not picking, I'm not even going to name the large institutions, okay? But whether they are fraternal or religious or some kind of community-based organization, I'm just going to tell you right now, there are lots of bankruptcies out there as a result of the board not acting as it was expected to be. There are a lot of institutions out there selling property to pay very big verdicts and settlements. I'm just telling you, from a place of real humility, not ego, that AA is not the only one guilty of it. A lot of non-for-profits think that they can operate so-called outside the bounds of what is accepted. So what does that mean for the person who asked this question? Let me give you an example. Your area signs a contract with a hotel. The contract is between the hotel and your area's corporate name, which is nice. That's good. And the person who signed it for your area is allowed to sign for your corporation. They're an authorized officer to sign. Then someone falls at the hotel. And guess what? The area doesn't have insurance. And then I'm not saying this will happen everywhere, but in some places, you lose the protection of your corporate protection because you should have been carrying insurance. And if you want to be a decent corporation in that state and a good corporate citizen, you're expected to act appropriately. And then what happens? Then the people that are named as the officers of that corporation might be personally liable. All I'm telling you is that no one thinks about these things until much after they happen. And I also feel like, from a trusted servant point of view, we don't want to put anybody in AA's house on the line, or bank account on the line, or property on the line. Like, we should be buying the proper amount of insurance and running our corporations the proper way. Somebody shouldn't be punished just because they did some AA service and serve as a director on a corporation. And, the last thing I'm going to say about this, and then I'm going to let it go, but I'll just throw out there another thing to watch out for. And the lawyers who handle nonprofits always write this in their advice. There's two different kinds of insurance. There's actually a million different kinds of insurance, but for this purpose, there's two that are really important to you. There's general liability insurance, which protects the corporation if the corporation should happen to harm something or someone else. But that doesn't protect you for your liability as a director or an officer. There is also something called directors and officers liability insurance. There's actually a part A and a part B. I don't want to overcomplicate it for you. But there are some people out there that say, oh, you only need that if you're a public corporation traded on the stock exchange. So what I want to tell you, there wouldn't be a special product for private companies if that was true. Okay. So I just want to let you know, in the insurance world, there is actually a special product for D&O for private companies. Some companies even go so far as to have a special product for private companies that are not for profits, that are tiered towards protecting the officers and directors on a non-for-profit corporation. I just want to tell you that it's just something that we don't spend enough time doing. And when you get into a jam, it's too late. You have no more contemporaneous records. And especially today, in today's digital world. Oh, I'm going to tell you something else right now. I said that was going to be the last thing. I'm going to leave you with one more. Okay. This is a new one on my, it doesn't matter if it's AA or other non-for-profits, but AA has another thing that we have a problem with. It's a really good spiritual thing, which is rotation, but it sometimes causes us a problem legally. So, how many, by a show of hands, digital or regular, how many of you are part of an area or in a group that is incorporated as a non-for-profit and has like email addresses for trusted servants, like steering committee chair at so and so in a group, or alternate delegate at area something like that. How many of you have that? Okay, lots. Okay, so here's another really good one. You do not have the right to destroy your emails before you rotate out of your position. And you better make sure that your area or in a group knows the digital retention policy for nonprofit corporations in your state. Because this just happened. Again, I can't name where because we don't pick on people, but it was a slip and fall. It was outside a strip mall type office rented by an AA service entity. One of the discovery requests was any and all communications regarding any notice for the defect in the sidewalk that was outside the office, right? And you know what the lawyer for the insurance company was forced to tell the other side? Oh, most of our trusted servants, when they're at the end of their office, because they have that mailbox, they deleted it so that the new person taking office wouldn't have their old emails. So I just want to let everyone know here, you're not allowed. Well, you might be, but you better make sure you know the digital retention policy in your state for corporate records, because just about every state has one. And if you are not automatically backing up deleted emails, and I know everyone's going to say, Billy, that's too complicated. It's too nonprofit governance. I'm just telling you, it's not. And it's not if you value your nonprofit status, that you like not having to pay tax and you like all the benefits that come along with that. I'm not going over the top. These are simple things that are just requirements. I can tell you right now, AAWS, AA Grapevine, and the General Service Board all have backup that goes above and beyond the state of New York compliance so that no one can delete an email. You might think you deleted it, but it is in the backup system so that it is there, so that there are no deleted corporate records of any type. You might also notice that trusted servants, elected trusted servants, do not have email addresses at AA Grapevine, AAWS, and the General Service Board. They use their private emails, and any emails that are going back and forth, like I said, are not deleted. Even if you hit delete at the General Service Office, it's being backed up. Most areas and intergroups do not have the infrastructure to do that. So someone just wrote me a note. I'm sure it's a good one. Well, someone told me we had a person not legally listed as an officer signing contracts for a hotel for an area event. I brought that up, and that is changing. Good things to know. Yeah, you don't want someone individually. Oh yeah, here's another great comment. Worse yet, failure to keep records can and probably will be held against the area. Oh yeah. So I want to just let you know this right now because that person just predicted the end of the story about the good old slip and fall. Because now I work in the insurance industry, so it wasn't surprising to me. But what happened in that case is what happens in a lot of these cases with deleted records. Is the judge will give an instruction to the jury that the jury is to assume that there was some record in there that you would not want them to see. Now that sounds horrific and it sounds unfair, but you deleted your own stuff, not the other side. If there was nothing to hide, you shouldn't delete. Um, but it seems, in most states, this is a pretty uh, common thing with trial judges. They love the word, is it spoliation? Um, but they don't like records that are destroyed, and it will never be used against the person who is bringing the claim. It will be used against the person or the side who didn't keep accurate corporate records or deleted them. It's such an important point. Okay. Um, we will go through the rest of AAWS and AA Grapevine next week, but I'm glad all this nonprofit stuff gets out because it's so hard in AA. I will tell you, and so it's on the tape, that every state, I think every state, it's so easy to contact your attorney general's office and get the basic governance information for nonprofits. It's so easy. I mean, I'll just give you an example. Um, I'm sure if I go to my AA file and I go to AAWS, I can find, yep, New York Attorney General's office. And here, the state of New York publishes this right from the start: responsibilities of directors and officers of not-for-profit corporations. This is something else that should go to every person on your steering committee or your general service executive committee or table committee or whatever you call it. Everybody who's a legal officer. With the bylaws, they should get this document. The state of New York also publishes State of New York Office of the Attorney General, Charities Bureau, internal controls and financial accountability for not-for-profit boards. So there's lots of help out there, I think, is the point I'm trying to say. And hopefully none of the lawyers get mad at me here, but I would also tell you that I say this with the greatest respect for lawyers, but I mean lawyers who are working for a professional fee in their area of expertise. If you tell me that your lawyer is somebody on your committee who just happens to be a lawyer who doesn't usually do this type of thing, I would tell you that that can be a recipe for disaster, a real recipe for disaster. It's just a big problem. I'm not saying you can't have a pro bono lawyer. Your area can decide if that fits within the traditions or not. I know what I think. But I also know this. When you're paying for a service, I use the AADJ rule. And I don't want to offend any lawyer because DJs didn't go to law school or whatever, but it seems to be the same rule applies. If you're not putting money in the bank for the DJ and food on the table for their family and paying them a reasonable rate, you're going to be the last party that they're thinking about every day. They're not going to be thinking about the last Friday of the month AA anniversary dance that they agreed to DJ. Not when a wedding and a bar mitzvah and some retirement party is willing to pay them for their expertise at being a DJ. The same comes with every professional you hire. If you're treating them not like a professional, you will not be on the top of the pile. And so I'm not saying you can't have someone who's in AA do this. I'm just saying you should be very careful and make sure that if they agree to do it for free, that they're going to handle it the same way they would handle a paying client. that they would give you the same service and the same care. So just a couple of things to consider. Um, we'll go through the grapevine bylaws next week. They're a little bit different. We'll talk about the last couple of articles from AAWS. But does anyone have any other questions? I want to go back to the conference quickly. Any other questions? Everybody understands board weekend was this weekend. The General Service Board meeting, the official meeting was today. They blessed the final conference agenda. Another public service announcement. If you need something from GSO, give them a break the next 2 weeks. They're working on background, and that background needs to be translated, and it needs to go out to 93 delegates. And, now is not the time to say, well, I really need this help from staff. I'm not saying you can't. I'm just saying that it's a very busy period of time. So that's it, everyone. Have a great night. See you next week. We will end with the responsibility statement. I am responsible. When anyone anywhere reaches out for help, I want the hand of AA always to be there. And for that, I am responsible. Thank you.